regarding note taking and things of that nature. So if you want to have your video on, feel free to. If you want to have your video off because you're working in the background or what have you, feel free to have that off. We ask that everyone stay muted to reduce background noise. So if you want to ask for clarification or ask a question a bit later, you can unmute yourself or put that in the chat. Please remember that the chat is not for discussion or legal advice. That is to ask a clarifying question. I don't believe we've had any issues with that recently, so thank you for cooperating with that. And speaking about legal advice, this Q&A is not legal advice. We are giving general legal information that is maybe helpful to the community associations in Washington State. So if you find someone saying, well, condo law said X, or pointing you to a particular publication, such as one of our books, the Q&A, what have you, it's not legal advice. Your particular facts and circumstances that you are facing may be different. We have had community members in the past contact our office and say, well, you said X on the Q&A, but you're saying Y now. What's the difference? It's because the particular facts and circumstances of that particular association and that particular issue changed what is generally applicable. So do not rely on the chat, on the Q&A. If you have a question that you need answered and need to rely on that answer, contact your community association attorney because they're the one who can give you advice regarding your particular facts and circumstances. So the next topic or next thing is please review the prior Q&As for Q&A videos on YouTube. We have Q&As up to, I believe, April of 2020. So there's a wealth of information there. But recently we've been doing little short classes or primers on upcoming legislative changes and other general topics. If you have a topic that you would like considered for a primer, please email info@condolaw.net. If you have a particular question that may have been answered in one of these primers, feel free to go onto our YouTube channel and search the channel itself for that particular topic. And just a quick reminder, there will be no Q&A next week, which is July 2nd. We hope everyone enjoys the 4th of July holiday. And without further ado, I think we were going to do a quick primer on insurance.
Okay, thank you, Jennifer. So the insurance topic has come up because we have had an increasing number of clients come to us where they've had some kind of a loss and their insurance or their contractor's insurance has declined to pay anything. And so they're wanting to, us to somehow force the insurance company to pay for the loss. The challenge is that we need to start with what the contract for insurance says that the client has purchased. And we discover frequently that the insurance contract or the policy has never been read by the client or the manager. And so they really don't know what insurance they bought. And when we get the language of the policy, we have to basically tell our client that they bought a policy that has no coverage. And so what we want to do is first encourage people to actually have their policies and read the parts which talk about what the coverage is and what the exclusions are. So historically, coverage would start with a base of fire and everything that damages the building. It's sort of this all-inclusive, You know, if something bad happens to your building, there's insurance coverage for it. And then there's a list of exclusions. And the exclusions are usually fairly specific and fairly lengthy. And the exclusions will include things like floods and water seeping through foundations, slow leaks. But that list has been expanded in the last few years to also include things like faulty workmanship or defective products which have been installed in the building. What we've been seeing also recently is more policies which, instead of covering fire and everything that's not excluded, limit the coverage to only a list of things which have been stated in the policy. So it will only cover fire or an airplane hitting the building or riots or trees falling on the building, but it will not cover anything that's not in this specific list. And the things which we're seeing excluded most frequently are anything related to water. You know, we had one policy that came through our office in the last month where if it was rainwater, it was excluded. If it was water leaking from a pipe, it was excluded. If it was water that overflowed a tub, it was excluded. Basically, there was zero coverage in the policy for water. It was a really inexpensive, affordable policy for the association to buy, but it was because it did not provide the coverage which they were hoping to get after they had a pipe burst. Okay. Other exclusions which are being increasingly enforced are exclusions for faulty workmanship. So we had a client where they had a new roof put on their building, and less than a year later, they had a storm and the roof leaked and caused significant damage to the interior of the unit. And the association's policy declined coverage because the source of the leak was the faulty workmanship by the contractor, and faulty workmanship was excluded under that policy. Okay. So it's important to understand when you are buying an insurance policy what coverage you are getting and what exclusions apply to that coverage so that you can make a decision about the cost and benefit of the policy you're buying. Another piece of that might relate to what the deductible is under your policy. You know, the days of low deductibles like $5,000 on an HOA policy are mostly gone. We are seeing clients with deductibles of $100,000, $250,000. We've got one client where the deductible is $500,000. And these usually occur because the client has had at least one fairly significant loss, and the insurance company is not willing to place insurance again unless the expected loss is fully a risk that the association is bearing. So the client that's got the $500,000 deductible was because they had a water pipe that burst and they flooded, I think, 20 units in the building, and the loss was over $700,000. And when it came time for renewal, the insurance company just wouldn't do a deductible less than $500,000. Okay. The other thing to be sure you're looking at is when you hire a contractor, you need to be looking at the insurance they have. It's not good enough for a condominium to look at the Department of Labor and Industries website and confirm that the contractor has insurance, because the insurance may have an exclusion for work on condominiums. You know, one of the same clients we had come through where the HOA insurance declined because of faulty workmanship. The contractor's insurance declined because they had an exclusion for condos and multifamily housing. And the association had tried to confirm that there was insurance. They saw that it was insured under the Department of Labor and Industries, but the insurance company declined coverage because of the condominium exclusion. So you need to get a letter from the insurance agent or the insurance company I don't think you can trust the contractor telling you they have the insurance. You need to know from the insurance company. And it's important for you to know whether there's going to be any coverage. Okay? And it'd probably be helpful for you to actually understand what the contractor's insurance excludes as well, because we've run into situations with a roofing contractor where they had what was called an open roof exclusion, which meant that during the course of the work, while the contractor was performing their work, there's no coverage for rain if if it rains during the course of work, because the roof is open, it's unprotected. And we also know that those policies can have faulty workmanship exclusions, and they can also, so there's a lot of risk which associations may think they're covering because there exists some kind of an insurance policy. But it's important to understand what the exclusions and exceptions are so that you can actually understand what your risk is and make sure that you're protected. Many of the condominium documents have a very specific allocation or requirement for insurance, especially for the property insurance. And we've run into situations where the declaration requires that the association buy insurance for the common elements, the units, and all the betterments within the units. But the policy that the association purchased does not include the interior of the units. So if there's a loss, there's not going to be coverage under the HOA's policy, and the association will have breached its obligation to comply with the declaration and provide that insurance. So Jennifer, is there anything you want to add about insurance for this?
I think we've covered this as much as we need to right now. So our first question, do you think that an in-window AC unit would be included under 6438-180 section on heat pumps? And just an aside to everyone, the legislature amended statute, was it last year or the year before, regarding heat pumps? It's in all of the statutes. It's in 6490. So the language in 6490 is 6490-580 sub 9A. This language is the same across all the statutes. So what this particular section states is heat pump means a heating or refrigerating system used to transfer heat. The heat pump condenser and evaporator may change roles to transfer heat in either direction. By receiving the flow of air or other fluid, a heat pump is used to cool or heat. So we can't answer this particular question completely because we don't know. Does this particular model of an AC unit fall under this statute? We can't answer that question. You can trust with a vendor, you can trust, I'm sorry, it's been a morning. You can contact a trusted vendor to see if they can answer the question for you. You can check the materials from the manufacturer to see if that qualifies. But honestly, the underlying question here is, under this particular definition, or even if the definition doesn't really apply, what are you trying to do? What reasonable restrictions can you place, or are you allowed to impose, even if a window unit is a heat pump or not? And brass tacks, we could probably support a legal argument in either direction. It just depends on what you want to do. So contact a trusted vendor, try to get the manufacturer's materials, see if it's a heat pump. But what reasonable regulations are you trying to impose on this particular piece of equipment? And is there a way to make it work for both the association and the owner so there isn't a challenge? Ken, did you have anything to add to that?
Well, yeah, the other variable, which is also part of why we can't answer the question in this forum, is what the unit boundaries are for your particular community. Because the heat pump law only applies to heat pumps that are located inside the unit. And we've seen a number of associations where owners have tried to force the association to allow their heat pump when the heat pump is actually not inside the unit. And so the statute's pretty specific that you can't restrict a heat pump unreasonably, because you can restrict it, just not unreasonably. You can't restrict it unreasonably in the inside the unit boundaries. But some HOAs, the unit boundary is the exterior skin of the building. And so a AC unit sticking out would not be inside the unit. Next question. Is it common for CC&Rs to forbid feeding of feral animals? Okay. So this is something which we see really frequently within the rules, and it is almost always within the power of the board to adopt rules which would affect the feeding of animals in the common areas. We don't usually see this as a prohibition specifically called out in the declaration or CC&Rs. Okay. Reasons why you might want to prohibit feeding animals, whether they're feral or not, is that food outside attracts undesirable animals as well. Certainly we have problems in the urban communities with rats and squirrels being attracted, and I could certainly see problems with actually attracting coyotes and bears in more rural communities. So it's a reasonable prohibition in most cases to prohibit feeding not just feral animals, but any animals outside. Anything you want to add, Jennifer?
There was an addition in the chat. What about food in an open garage? So is this particular thing becoming a nuisance within the community? Do you have the nuisance language in your declaration that allows the board to regulate uses that become a nuisance to the community? This answer basically requires legal advice. So if you want advice regarding your particular situation, contact your association attorney. Ken, did you want to add anything further to that?
Well, we know that there are some owners who really enjoy feeding the wild squirrels and birds and wildlife around their homes, and they don't consider a nuisance. And so you do get differences of opinion, but if you live in a community, you end up having to adopt the community's standards. And that's I guess, the message we end up trying to deal with owners on when it comes to our office.
So our next question, is electronic voting absentee voting? The answer is not necessarily. And I'm citing to 6490, excuse me, because that's going to be effective starting January 1st, 2028. So 6490 455 sub 2 sub C states that absentee voting or ballots are used when owners will be voting at a meeting. An absentee ballot is drafted by the association and sent out to the owners ahead of the meeting, typically with the meeting notice, to allow owners who are unable to attend the actual meeting to submit their votes. It's an absentee ballot isn't necessarily electronic voting. It can just be a paper ballot. So electronic voting can be used as an absentee ballot or voting as long as the information is provided to the owners ahead of time. But it also is can be done as the sole method of voting without a meeting. And that reference is cited in 6490 455 sub 4. So absentee ballots and electronic voting aren't the same thing. They have two different applications, but electronic voting can be used as an absentee ballot if you're holding a vote at a meeting and want to do the vote electronically. Ken, did you have anything to add to that?
Well, I think there's some uncertainty about whether or not you can require people to use electronic voting. And my answer today would be is that you cannot require an owner to use electronic voting, especially if you're holding a meeting. So the statute was written to allow the combination of votes from people who are in person, who have sent proxies, and by absentee ballot. And if the goal is to use electronic voting to the exclusion of an owner's right to receive their notices in paper and vote in person or by paper, then I would be concerned about that. And we'd need to have a chat. Next question. If a husband and wife are listed on the HOA account and one of them passes away, does the deed need to be updated in order to remove the spouse from the account? And our answer is no. If you have knowledge that an owner has passed away, you can remove the name from the account. I suppose you could ask for probate documents to establish if there's a different person who should be added to the account as the representative of the estate. But the remaining owner should be able to update the contact information for you. There's no obligation to push an owner to correct or change a deed. Anything you want to add, Jennifer?
I think you've covered it. Our next question is, when a condo association does not file an insurance claim, even though the repairs exceed the deductible, do all units pay for the repairs or only the affected units, or does the association allocate costs as if an insurance claim was filed? I viewed prior condo law YouTube, but did not find anything addressing this. So the board always has the discretion to file an insurance claim or not. That doesn't change. What does change, what also doesn't change is responsibility for costs in excess of the insurance deductible. So your deductible shifting language only addresses costs within the insurance deductible. You cannot allocate costs above the deductible as if they were still within the deductible. I believe statute and your declaration typically state that costs in excess of the insurance deductible is a common expense. That's for an insured claim. An uninsured claim would be determined based on whatever language is in your governing documents. But this particular question addresses a claim that could be, damage that could be part of an insurance claim, but the association chose not to file. So if the association chooses to not file an insurance claim, the association must pay for everything that insurance would have covered. The costs are only allocated to owners when it's within the insurance deductible or as otherwise provided in the declaration. We need specific information to make this determination for any community. So we cannot give a blanket answer. There are just too many variables and too many provisions of the declaration for us that we would have to take a look at to give you an answer. Ken, did you have anything to add to that?
Yeah, so Jennifer, you have read this question as if the association has an ability to transfer the deductible amount to the owner. But I think that the vast majority of condominium declarations still require that the association pay the amount within the deductible. So whether you file a claim or not, however the condo declaration allocates the cost is how the allocation of the cost is made to the owners or to the association. Choosing to file a claim just doesn't change that. So
yeah, and one thing I missed, I'm sorry, Ken. If you have not amended your governing documents and your actually any community to allocate costs within the association deductible, you can't do that. It's not enforceable. Too often we get Either something comes through on collections or a question from a client asking or saying, hey, this owner is refusing to pay the deductible. We look in the governing documents and there's no authority for it. You cannot assume that because the declaration is silent, you can just do it.
Okay, next question. Is the minimum number of directors for an HOA board 2 persons? So it depends on a couple things, but mostly what your governing documents state. The Ukiah for the newer communities, or as soon as Ukiah applies to all communities, sets a minimum number of 3 board members unless you have fewer than 3 units. So if you only have 2 units, you could have 2 board members. Under the Nonprofit Corporation Act, it'll allow a board of 1. Under the Miscellaneous and Nonprofit Corporation Act, which is 2406, I believe that the minimum is 3, which doesn't make sense if you only have 2 units. But the short answer would be that it's, we would recommend 3 unless you have fewer than 3 units. And, Valerie wanted us to also comment that we do typically recommend you have an odd number of board members, because that would, in theory, mean you don't have ties where you can't make decisions. I don't know that it matters that much. You just need a larger number of votes if you're going to have an even number of board members. But yeah, the short answer is no, the minimum number is not 2. Anything you want to add, Jennifer?
No, I think you've covered it. So our next question is, when a committee has 2 board members and therefore can exercise board authority, how do we avoid a situation where they authorize funds beyond what the budget specifies or contrary to what the authorization would be if the full board voted? So if you have a particular issue within your community, talk to your community association attorney. This is not legal advice. So a committee can only exercise authority that is delegated by the board as a whole. So if there is a charter for that particular committee and that committee acts outside of their committee charter, that should be reflected in board meeting minutes or brought to the board's attention. And the board always has the authority to remove or disband that committee. Going a little further and maybe into the weeds, if a committee or individual board member acts outside of their authority, they can be personally liable for that particular action if there's a challenge. So there is some personal danger to that particular individual for doing that. But the resolution or committee charter that forms the committee would set limits on the authority of that committee and what they can spend. You can avoid issues by having a clear understanding about what authority is delegated to that committee. And the board should also have some scheduled meetings or regular oversight of each committee's actions in a board meeting, so you can avoid issues with overspending or unauthorized action by the committees. Ken, did you have anything to add?
Just that any of the actions of the committee which are exercising board authority need to also be documented and kept in the board meeting minutes, the same as if they were done in the board meetings. Next question. Our HOA has never had a reserve study done by a reserve study specialist or an audit done by a CPA, nor have we had a vote to waive the audit. Other than bad business practice and not complying with the RCWs, what are the consequences? Well, the most likely consequence for failing to have a reserve study would be a special assessment that would be required to pay for a repair because you didn't have the planning or savings to collect the money in advance. I suppose the potential for failing to have an audit is that you could have money being embezzled, which you don't discover because you don't have any outside oversight of the accounting. Um, the the risk may be small. I can tell you I am a member of a 2-unit condominium where we have an annual budget of $120. And we don't do reserve studies and we don't do audits. And I think my risk is fairly small because we don't have a bank account that has a lot of money that can be stolen, and we don't have any expenditures. The association didn't write a single check in calendar year 2024. So the particular circumstances of your community are going to establish what the risk or consequences are. If you're a large community, you could have an owner sue the association for a failure to comply with the audit requirement. The remedy for an owner to force a reserve study is actually stated in the statutes, in that it requires, I think, 20% of the owners to demand that the reserve study be included in the next year's budget. If that budget is then ratified, then the board has to do the reserve study. If the board refused to do the reserve study after that process, then I think there is the potential for some risk to the board members for failing to comply with their duties. But if you're really concerned about this, you might want to talk to an association attorney and figure out what the risk might be. And you could certainly eliminate that risk by simply getting an audit and getting a reserve study. Anything you want to add, Jennifer?
No, I think you've covered it. So our next question came in. It was actually too specific for us to answer in that form. So we've condensed it. For the individual who sent in the original question, you need to contact your community association attorney for advice. We cannot give advice to you in this forum. So the question that we're going to answer is, what is Estoppel? When is it used, and can you explain it? So Estoppel is a legal principle that basically states you cannot argue one thing or state one thing at one time and then later go and argue the exact opposite. The Black's Law Dictionary states estoppel is a legal principle which prevents someone from alleging something that contradicts a previous action or statement. Just Googling estoppel states that it's a legal principle that prevents someone from asserting a fact or right that contradicts what they have previously established as true or agreed upon. It's a bar to relitigation of issues and ensures fairness by prohibiting contradictory claims. It's a judicial device that upholds the integrity of previous statements or actions in legal proceedings. So estoppel is typically used when a court has ruled on a particular issue and then prevents the parties from coming back and relitigating the same issue again. Ken, did you have anything to add to that?
No, I think you've covered it. It's an easy one to Google also and research as much as you want. It is an unusual claim to be dealt with by the courts, but it is something that they do. Next question. Our HOA has a board of 5 directors. Our bylaws say 3 directors constitute a quorum. We also have alternate board members, and our bylaws say if a director isn't available for a board meeting, the alternate sits as a director for that meeting, complete with voting power. A question has arisen as to whether an alternate sitting in for a director would count towards making a quorum. So would 2 directors and 1 alternate constitute a quorum for a meeting? So again, this is too specific. We would need to see your exact governing documents. But I would say as a general rule, our answer is no, an alternate could not be used to complete a quorum. And we're basing that in part because of the requirements in RCW 6490-445, which applies to everybody starting in January this coming year, that says that a board member cannot have a proxy. And so an alternate is just a different way of designating a proxy for the elected board member. And so our answer is that no, you can't do that. But I will leave open the possibility that the specific bylaws or articles of incorporation might provide something different. Anything you want to add, Jennifer?
I don't think so. I think you've covered it.
I
And we're
will say that Jennifer had, when we talked earlier, said that we don't recommend alternates in large part because there's generally not any authority for them in the statutes, which is true. We think if you're going to elect a board of five, you elect the board of five, those are the decision makers. You don't then get to have three alternates. But, you know, we also know a lot of communities do things differently.
Well, and as long as their practice is in your governing documents, you're probably fine. If it's not, then there may be a problem. Contact your association attorney. We're almost to the end of our prepared questions, so if you have a particular question you want to add, please feel free to put it in the chat. So our next question, in general, can a condo board president make unilateral decisions and not inform other board members or put it up for a vote? So I'm just going to, based on the CAI message boards and things that we've seen, please refer to the kind of housekeeping chat at the beginning of this Q&A regarding legal advice. This is not legal advice. If you have a particular question or situation in your association, contact your association attorney. If you are an individual board member, you can contact an attorney on your own to get legal advice for your particular facts and circumstances. So in general, the answer is no. But we need to know a lot more about what's going on, what particular authority that board member was delegated, and we don't know whether or not this person was acting outside of their authority or statutory duty of care. So in general, outside of a board meeting or exercising delegated authority, specific delegated authority by the board, any board member is an owner with the same authority as every other owner. Just because you are on the board, it does not mean that you have more authority than any other homeowner unless you are specifically delegated that authority by the board. Typically, the only authority specifically delegated to the board president in the governing documents is the authority to run association and board meetings and then sign approved documents for the association. So all decisions not specifically delegated to a committee or an individual should be board decisions. Any action taken by a committee on behalf of the board must be documented the same as any board decision. Ken, did you have anything to add to that?
Well, I guess I would just add, if you have a president who you think is acting beyond their authority, the board can, at any meeting, remove them as president, and they can be just like any other board member, put a different president in place. So, last question we have pre-submitted is it a conflict of interest for a board to hire a family member or friend to do work for an association? What disclosures should be made to homeowners if the board chooses to do this? What recourse, if any, might owners have if they disagree with a board decision like this? Okay. So the Of course, the short answer is we can't tell you if it's a conflict of interest because we don't have enough facts or specifics. We do believe that if you're going to hire family, friends, or actual owners within the community to do work on behalf of the association of any kind, that you should be upfront and disclose that information. That doesn't mean you have to get approval of the full membership because the board was elected to make decisions. And there's a difference between a potential conflict of interest and an actual conflict of interest. And so we would have to evaluate which of those circumstances may exist for the particular service for which someone is being hired. There may be a difference between hiring a family member to do simple bookkeeping for the community or hiring a contractor to replace the roofs on the buildings. And it's certainly possible that the family or friend is a better deal, even if there is a conflict. And so it's not really possible to evaluate whether it's a good business decision at the same time as whether or not there is some kind of a conflict. So sometimes the community's documents will actually contain some kind of provisions about how contractors are hired or about conflicts like this. But I guess really there's too many variables for me to know if it's a problem or not. We do in some of our governing documents recommend that if a board member or family member is going to be hired for something, that it be called out very specifically in the budget for the association so that the membership is aware of that at the time they do the ratification of the budget on your annual meeting. Anything you want to add, Jennifer?
Yeah, the last part of this question was what can owners do if they disagree with a board decision? So you can address the board at a board meeting and lay out your concerns regarding that particular situation. You can try to get elected to the board, and so you have more authority to deal with that particular issue. You can try to get people who agree with you elected to the board. If there's enough owner concern regarding this particular issue and the board isn't addressing it, you can try to recall the board. The provisions for that are in the typically in your bylaws. If you can't find recourse any other way, you can also sue the association to enforce the statutes and governing documents. The appearance of a conflict or even an actual conflict may not violate statutes or the governing documents. So you would need to speak with an attorney regarding this particular issue. Ken, did you want to add anything more to that?
No, I think we're good.
Okay, Chelsea, do you want to grab stuff from the chat?
Yeah, so first one I've got is because renewals come in so close to the date, say 20 to 30 days out, would it be better to have the attorney review the current policy and suggest changes for the upcoming renewal ahead of time? It's related to the insurance question.
Well, I would say that is an excellent idea to review your current policy so that you know what it is you're buying if you just get a straight renewal. We have clients where they have purchased the same policy with the same exclusions for years before they have submitted a claim, and then they're surprised when they don't have coverage. So yes, an examination of your current policy is a really good way to start, especially if you think that the proposals are going to come in very close to the date you have to agree to commit to buy it. And I agree that is a problem with the insurance industry, which we cannot control. And it's true for us buying professional liability insurance as well, where, it's not uncommon for the insurance company not to bother with giving us a quote until a week before our policy expires. And the people who put pressure on the insurance agents early may get better information early. But yes, figuring out what you have with your current policy first is a good way to go. Some insurance agents can help you with figuring out what the policy says. If you don't have a copy of your policy, though, it's going to be impossible for you to figure it out. And if you want an attorney to review it for you, they will need the policy. And a lot of people mistake the insurance invoice that they get, which might be 10 pages long, for the policy, because the policies are usually more than 100 pages long. And frequently the policy will contain somewhere between 10 and 20 different documents, because you're going to have endorsements for Washington State, endorsements for condominiums, endorsements for terrorism, endorsements for flood, for fungus, for mold, for employer liability. I mean, it's just a whole bunch of different policies which get cobbled together to create what it is you're buying. And it's not uncommon when we finally see a policy for it to exceed 200 pages. We don't have to read all 200 pages, because the property portion, which explains what is covered, is usually only 1 page long. We just have to find it. And then the exclusions are usually 3 or 4 pages long, and they're in the same piece of the policy as that. Though we do have to also look at the Washington changes and the condominium changes to make sure that those initial property policy provisions were not modified. So, anything you want to add, Jennifer?
No, I think you've covered it.
All right. Often overconcerned or just plain nasty owners will cause the board to seek legal advice, and then those same owners will complain about the legal fees, seemingly ignorant of the relationship to their actions. Is there precedent for a policy that charges back to the owner for causing frivolous legal fees?
Well, this is going to be when you're trying to charge something back to an individual owner, contact your association attorney to see if you have that authority. If it's not in statute or your governing documents, you won't have authority to do that. And to get specific advice regarding that situation, you need the attorney to tell you. But generally, if you have the misconduct provision, it allows charging some costs back to individual owners when they commit misconduct. Misconduct is not defined in statute, but it can be something that arises from an owner just being an absolute pain in the butt. There are too many variables to answer that particular question, because we can't give a blanket answer. It's really dependent on the facts and circumstances of the particular issue. We have certain clients where we have charged costs back to an owner for misconduct. We have particular clients where owners have harassed the board and or association manager to the point where they meaning the individual owner, was sent a notice in writing that any communication with the board or association manager regarding their particular unit or lot was to come to our office, and those costs were to be assessed back to them as misconduct for their misconduct of harassment. So it depends on your particular facts and circumstances. Contact your association attorney for actual advice. Ken, did you want to add anything to that?
Yeah, the Condominium Act has a specific misconduct provision, which Jennifer's talking about. Ukiah has a misconduct provision, which is similar, but it requires a notice and an opportunity to be heard before any costs can be assessed. The HOA Act and the old Condo Act don't support any assessment, but the individual governing documents you have may. And so it does require reading it. At least one of our other attorneys in our field has routinely put into their governing documents that challenging a board's decision that results in attorney's fees can result in those fees being assessed to the owner, even if no litigation is started. And that particular provision has not been tested in the courts yet. It may or may not work. You also need to decide whether it's worth the effort and the additional legal expenses that you will incur by trying to assess the initial legal expenses against an owner. And I would suggest that in most cases, that's not going to be a good investment to try and collect the additional attorney's fees.
I would also point out that if you try to assess something to an owner and they fail or refuse to pay, when the account goes to collections, the collections attorney has to do a separate analysis to see if those amounts are actually collectible. So if you don't have the authority to assess that particular cost, you assess it, they fail or refuse to pay, it goes to collections. You're just going to get an answer from the collections attorney that we can't collect this. There's no authority for it.
Yeah, you also cannot foreclose on a home for attorney's fees. So if they're paying their regular dues, you might carry it the same as a fine and be unable to use the primary collection weapon. But let's move on. Chelsea, you got something else?
Right. Have you observed that courts are holding directors to be more responsible for being more educated on their duties and adherence to the RCW?
No, not at all. I haven't seen any cases where it's even come up as an issue.
I would point out, though, that you have a statutory duty of care to use sound judgment and be reasonable. So while the courts aren't specifically stating, well, you're a board member, you should know this, it comes down to, were you being reasonable and were you following your duty of care? The court did find in Riss v. Angel, we've talked about that case before, that the board in that particular association violated their duty of care, even though they may not have known that they had that particular duty of care. So while courts aren't specifically pointing that out, it's still kind of an underlying thread. So you just need to be careful. Ken, did you want to add anything to that?
No, I think good faith is the other big thing that the courts might look at, and that was something in Riss v. Angel, because the board member was not acting in good faith, and it was the rest of the board that was failing to meet their duty of care. So, anything else, Chelsea?
Yeah, if a homeowner hires a handyman to pressure wash sidewalks or miscellaneous repairs, is the HOA at any time liable for damage to a condo unit? Wouldn't it be at the homeowner's own responsibility?
There's a lot of very fact-specific things that I don't think we can answer this question. There's no way to eliminate risk. If a part of the condominium is damaged by any source, then the association may have responsibility for it. If an owner does something bad or a contractor does something bad, maybe they have liability for it. So I don't think we can answer the question.
Check your governing documents. contact your association attorney because there's typically 4 to 5 provisions that we have to look at to determine responsibility for damage. Damage is different than regular maintenance. They're two completely separate analysis. Do not treat damage the same as you would regular maintenance, repair, replacement, because it does not work that way. Ken, did you want to add anything to that?
No, we'll see if Chelsea's got something else for us.
No, that's it.
Mm.
Unless we have a last minute thing coming
Well,
in, but I don't see anything.
I'm willing to be done for the day. Thank you, everyone, for joining us, and we'll see you in 2 weeks.
Bye, everyone.